So, Mr. Ostojic
Thank you, Mr. President, Your Honors.
is being a man.
We left off discussing briefly the evidence that was proffered by the prosecution in connection with Mr. Deronic. They don't ever reconcile for us, quite candidly, the fact that Mr. Deronic claimed that he got instructions from Karadzic. Although they were pretty wild in some accusations and inferences that they made, I can probably be certain that they will try to use that evidence in other cases before this tribunal. But they should reconcile that if it's true that Karadzic gave Mr. Deronic instructions on the 8th and 9th of July 1995 to kill the POWs from Srebrenica, it's clear then that there was no need for Karadzic to send this purported messenger, courier, or person to give Mr. Deronic the same information, which is what I think they're saying in a nutshell. At the end of the day, the prosecution cannot, certainly, with all due respect, rely on Deronic's testimony with respect to Mr. Beata for a number of reasons. They know and respect the law of this tribunal. I'm confident of that. They know that there should not be, at any instance, evidence that is tainted, replete with lies, false innuendos, to be brought forth against a witness. They know the penalty for perjured testimony. But what I don't understand and what they haven't reconciled for me is how and why do they rely on that testimony? The law is clear that Deronic's testimony, given that it is asserted against an accused, not subject to cross-examination. They know what the appellate court and trial chamber has said about Deronic. Essentially, that his testimony is not credible, should not be relied upon without any corroborative evidence, both testimonial or documentary. They know the intercept of the 13th of July, P1149, at 20:10 hours. Having all that, they don't reconcile for us how and why they think he's credible and reliable, and whether you should give that witness any weight. Their silence, perhaps as others have said, may be deafening. But in this instance, their silence with respect to Mr. Deronic is a clear indication that they likewise see and appreciate the fact that Deronic's testimony is simply a lie. No other witnesses up to this point, the 13th of July, have been brought forth by the prosecution. So logically, that takes us to the next day, the 14th of July, 1995. Again, Mr. Van de Puy uses a standard to claim that Milan Kerkez, Mira Cekic, and Svetlana Gavrilovic, that you should scrutinize their testimony carefully, that you should, if they make an inconsistent statement or an implausible statement, reject it in its entirety. I repeat what I've said earlier. I'll accept that standard so long as it applies to all the witnesses that the prosecution brought forth. If there is an inconsistency and there is no corroboration, or there is evidence to the contrary, that evidence should be rejected as well. In a nutshell, on the 14th of July, the prosecution provides you with 3 witnesses that they claim support that Ljubiša Beata was, of all places, in Zvornik, in Bratunac, in Nova Kasava, in that order. If you carefully, as I know you will, review that evidence, you will find that that timeline is not only implausible but impossible. The first witness that the prosecution relies on, Milorad Birčaković, his testimony was rebutted, his testimony was contradicted by the prosecution evidence with respect to his travel logs. They themselves also indicate that it is not possible, the evidence that they disclosed to us at P296, that travel log reveals that he did not go from the headquarters to an IKM. That evidence shows the time, the date, 5 people that he was traveling with at that time. Not only do the documents contradict Milorad Birčaković, who initially claimed that he brought Drago Nikolić from the IKM to the headquarters and that he claimed that he saw Beata at the Zvornik headquarters. What's important in this analysis is to review the timing of when it occurred. And again, he states that it was 8:30, to be fair to the prosecution. He tells us how long the meeting purportedly took place. He tells us how long it took him to go from Zvornik Brigade headquarters to the IKM and back. He then tells us when they purportedly left. Interestingly, witness PW162 seems to be having a meeting alone, with no one else to support it, with Mr. Beata in Bratunac at or approximately the same time, 9:30. It's impossible to reconcile these witnesses without taking them together. You've been to the site. You know how long it would have taken you to travel there under better conditions. I dare say that at the time that the prosecution alleges, the 14th of July, that the conditions did not allow for quicker travel to get from one place to another within such a short period of time. What's complicated about the prosecution's theory is that they add another factor. Although Mr. Butler thought that Vincent Egberts saw Beata on the 13th or 12th by virtue of his testimony, it is now pretty clear, and I could give the court the cite if it wishes, that in fact Egberts claims to have seen Mr. Beata on the 14th, and that's what's claimed by the prosecution. Again, in the morning. In a nutshell, their case on the 14th of July 1995 is that Beata was in 3 different places at or approximately the same time with 3 separate individuals, but according to the prosecution, we do not have corroborating evidence for any of those 3 instances. With respect to PW162, who claims that he saw Beata in the morning of July 14th, 1995, we need only look at what he said at page 9627 and 9628, where he cannot recognize Beata. Our brief goes into greater detail at paragraph 116 in that regard. PW162 is the individual that Deronic spoke about when he said that he had these close connections and that he could reinvent the chronology of events. PW162 was troubled by the fact that we knew during his testimony that he had spoken with Deronic. He first seemed to deny it, then he recalled it, then he simply dismissed it. PW162 is the individual who claimed that when he went to see Beata at the SDS offices, that the secretary called him in to visit with Beata. There's no secretary or evidence from a secretary to confirm such a claim. There's no record of the SDS offices to support that these meetings ever took place, much less at the SDS offices. The circumstances of the meeting that witness PW162 gave evidence on are suspect as well. He claims that Beata brought him to the SDS president's offices to talk to another colonel and a lieutenant colonel, who again, like PW161, they don't know who those other individuals are. They can't remember. In fact, during their bald-faced slide, they said those individuals were never introduced to us. These unknown sources by these witnesses, both PW161 and 162, clearly reveal the lies in their stories. PW162, unlike PW161, says that Beata was not in the office with the 2 other individuals, but that he just merely brought him in the office and stayed outside. PW162 and 161, although although in their clever attempt to implicate others, clearly mixed up their story. They both wanted to have the same story so that a prosecutor, an investigator, or perhaps even a judge would believe that such a meeting took place. It did not. There's no evidence to support either the claim of PW 161, 162, or Milorad Birčaković that would be considered independent or credible that this court would be able to rely upon. Given the fact that there's no corroborating evidence, given the fact that there's no testimony from other individuals to support, to confirm, or even to mildly recollect similar instances, I suggest with all due respect that the court reject the testimony in its entirety of PW 161 and 162. That leaves us with Mr. Egberts. My comments earlier about Mr. Egberts obviously still hold true, as does of our brief. Mr. Egberts is unique and presents a unique problem for the defense. He seemed, and I'm sure he was, genuine in his comments that he gave. However, in a criminal proceeding where the prosecution, with all due respect, is seeking a life sentence, I respectfully believe more is required. More than just the testimony of one individual who seems genuine, who seems independent. The prosecution had the wherewithal, had the knowledge, and certainly has the experience to have brought forth to this courtroom corroborating evidence as it relates to Mr. Egberts. Instead, what do they offer you? They offer you an aerial shot to show that there were indeed Bosnian Muslims, POWs, in Nova Kasaba. I don't think we're disputing that. I think we're disputing that it was actually Mr. Beata at Nova Kasaba. The Honorable Judge Kwan asked me during this case, early in the case, when Egberts testified, what's your position? Unlike the prosecution when asked questions, I responded directly. I could have, and some advocates suggest that I should have merely said, Honorable Judge Kwan, I don't have the burden of proof. I don't need to answer that question. They have to prove that Mr. Beata was there. They easily could have proved that, chose not to. That inference, the fact that they refused to call Zoran Malinic, that they refused to call the interpreter Nebojša, the fact that the prosecution refused to call Theo Lutki to substantiate or corroborate Mr. Egberts should be examined very closely. If those individuals, any three of them, remembered, recalled, or knew that Mr. Beata was there, we would have seen those three individuals. The inference is clear. Those individuals did not and do not support Mr. Egberts on this point. Quickly to turn to witness PW 104 that the prosecution alleges in their list of 14 witnesses that purportedly saw Mr. Beata. This witness also claimed that Mr. Beata was at the Zvornik Brigade headquarters on the 14th of July in the evening. With respect to his testimony, I think once you review it carefully and cautiously, you'll find that it's implausible. He was a local civilian who worked with Daronic and the Bratunac personnel, both in 1992 through his relations through other individuals who were elected office in Zvornik. With this witness, as with 10 other witnesses that the prosecution has brought forth with respect to the presence and identity of Mr. Beata, there is no corroboration. This witness in particularly says that he cannot recall which officers of the Zvornik Brigade were present when he met with Beata. He cannot recall how many persons were present during this purported meeting. Likewise, he could not confirm the identity of Beata. Look closely in his other individual on the 14th of July, 1995, and that's Marko Milosevic. He's, as we know, the deputy commander of the Zbornik Brigade, 6th Battalion. Now, here's an individual who wanted to try to tell us that he did have corroborating evidence with his deputy, of all people, Ostoja Stanisic. Together, these individuals want you to believe that near or around the Petkovsky school, which was close, I thought he said that when he claimed to have seen Beata, he walked over to the school. Prisoners were held at that school, of no concern to Mr. Stanisic or to Mr. Milosevic, apparently. He walked there and simply conveyed a message to Mr. Beata. How plausible is that? How realistic is that, that a deputy commander and a commander of the 6th Battalion, knowing, seeing, appreciating the situation, would not have reported it to someone? Would not have recorded it anywhere? If it's true that Beata was there, all they had to do was write it in their logbook. It's a positive thing for them to say, hey, look, bad things are happening 5 seconds away from us or 5 minutes from where we're at. Other people are there. We don't want to get involved in it. Instead, they tell you that when we came back to the command, they heard shots. They knew what was going on. I challenged Mr. Ostoja Stanisic and said that he was involved in the killings and his men were involved in the killings. He took it rather personally, as he should have. It is not possible for a commander or a deputy commander such as Marko Milosevic to say with any credibility that they knew what was going on at Petkovsky school, that they went to Petkovsky school, saw Beata, but didn't record that anywhere. It's not plausible, their story. You heard, although it was not revealed to us from the prosecution, these two individuals were interviewed by the prosecution on the same day. They traveled together for 3 or 4 hours in the car before they meet with the prosecutor of the ICTY to discuss Srebrenica and their involvement. They again lied and said, we really didn't discuss the events. We talked about various things, but we didn't want to discuss it. They weren't serious. It's not plausible. It's not possible that in a 3-hour ride, if it's true that they saw Mr. Beata, and if it's true that they knew that there were POWs in the Petkovsky school, it's not plausible that they didn't discuss it on the car ride to visit with the prosecutor in their first interview. They concocted the story. They've made it up in order to shift the responsibility because they knew that they were responsible. It was within their zone of responsibility, Petkovsky school. The least they could have done, and what they should have done, if there is any truth to their claim that Beata was present, was record it. Later, they could use that to try to absolve themselves of responsibility. They didn't do it because they couldn't do it. They knew that Beata was not there. Now, they claim they conveyed a message to Beata. No one else confirms that they saw Beata at Petkovsky school. No one else confirms that Beata went back to where Ostoja Stanisic was to make this phone call. Nowhere in the logbook do they write down, yes, we've given the message to Colonel Beata. I think those logbooks are highly suspicious, and I'll address that issue later in my arguments and submissions. There is no doubt that Ostoja Stanisic and Marko Milosevic coordinated their testimony. There is no doubt that it's impossible to believe that these two people who are placed in charge of a battalion would not have notified others of the circumstances involved in Petkovci. And there's clearly no doubt that if it's even remotely true or possible that a third party such as Mr. Beata was actively engaged in any activity at Petkovci, they would have written that down, they would have shared that with others, and they certainly would have been able to use that as to absolve them of any responsibility in those crimes. Again, with respect to Marko Milosevic, there is truly no corroborating evidence. There is what the prosecution says, some consistency that the record mentions looking for Beata or convey a message to Beata. However, we are in a criminal trial, and the standard of proof is not that there's consistent evidence, there must be conclusive evidence. Such conclusive evidence does not exist as to any of the purported identities of Mr. Beata and his presence at any of the sites or venues as claimed by the prosecution. July 15th, 1995. In the evening, prosecution in his brief relies on one witness in this regard, and that is PW 165. PW 165 spent the entire day, that day, guarding and watching the POWs at Rochevich School. Upon return to the barracks, someone, again, consistent with what they're telling the court, an unknown person told PW 165, quote, well, the commander had a meeting with Popovich and Beata, end quote. This witness's testimony is not only, as Mr. Vanderpuge says, valueless, it is truly worthless in the regard of identity of Mr. Beata. This witness was not corroborated by anyone. This witness doesn't even remember who told him that it was Beata. This witness also claims that on the 15th of July, 1995, when he references the commander, he references Obrenović. Look at what PW 168 says about Obrenović. And I know I said that inartfully. Look specifically at that testimony. PW 168 denies being present at that meeting. Look further at PW 168's testimony and examine OTP brief at paragraph 867, transcript of PW 168's testimony at 17,061, where he clearly says that he never saw Beata from the 12th through the 18th of July. PW 165 also acknowledges and admits that he never saw Beata before or after this incident, or during. He simply says some unknown person told me that they were at the barracks. PW 165, as a military policeman from the Zvornik Brigade, clearly would have told us if he had seen Beata at the Rochevich School or anywhere near the Zvornik Brigade on the 15th of July. PW 165 and his testimony are, again, as I've stated, in my view, respectfully worthless, and no weight should be given to it. The next day, the 16th of July, 1995, again, the prosecution relies on solely one witness. We invite you to look at our brief again at page 130, paragraph 424, with respect to the analysis of Mr. Slavko Peric. But quickly to share with you what he said. Peric admitted under oath that he, quote, cannot say with any certainty, end quote, that the person he purportedly saw was Beata. Transcript 11,411, May 11, 2007. He told the court, being subject to perjury charges, I cannot say with any certainty. The prosecution chose to ignore that evidence. They chose not to try to reconcile it for the court, and they simply stand by his inconsistent version when and if he actually saw Mr. Beata. Again, with this witness, Slavko Peric, as with PW 165, 161, 162, Boško Momčilović, and others that I've highlighted, there is no corroborating evidence to support or to be able to even give any weight to the testimony of this person who claims to have seen Beata on the 16th of July, 1995. Now, the 16th of July, 1995 seems to be a good transition for us to look at some of the intercepts. But before we do that, I just want to highlight again, of the 14 witnesses that the prosecution claims that they support that Beata was present at or around Bratunac or Zvornik, 10 of them were not corroborated. 10 of them had no records to support what they were claiming. 10 of them saw, heard from unknown sources, were unfamiliar with Mr. Beata, as described by Professor Wagner in his testimony. What the prosecution, I think, respectfully missed the point of Professor Wagner. They seem in their brief to embrace and endorse his view. All Professor Wagner was trying to tell us is that there is a clear methodology and a way in which, if you're going to have identification evidence, that there's a procedure as to how you should follow it. We did spend an awful lot of time going over the characteristics of Mr. Beata. They were clear, they were distinct. The witness's testimony in that regard were also inconsistent. And I ask and invite the court to review that when determining whether any weight should be given to these witnesses. If 10 out of the 14 witnesses had no corroboration, had no support, or as the prosecution called, were either liars or gave false statements, what 4 are left? The 4 witnesses that are left respectfully are Momir Nikolic, Miroslav Deronic, PW 161, and Ljubomir Borovčanin. If we exclude Mr. Borovčanin, which I shall, there's 3 witnesses in this case who claim that they have seen Mr. Beata. And if you add PW 162 to these 3 witnesses, those 4 witnesses, examine their testimony closely and you'll find the inconsistency. You'll find not the loophole in order to acquit Mr. Beata, you'll find the fairness and thoroughness which is required in these proceedings, that the prosecution failed to meet their burden of proof beyond the reasonable doubt. Double check PW 138. Let the prosecution tell us why they chose to abandon his testimony. Look closely at Zlatan Celanovic, and you'll find that Mr. Beata was not, could not have been, and there's no support that he was with him in Bratunac at any time. Is it a coincidence or convenience that the Zvornik brigade persons who testified had no corroboration, had no support, but yet claimed that Ljubisha Beata was present at certain times? With respect to the 14th, as I've already stated, the timeline makes no sense for an individual to go from Zvornik Brigade headquarters down through to Bratunac, back up towards to Nova Kasaba within that short period of time. The burden of proof rests with the prosecution. With all due respect to them, they failed to carry that burden on each and every instant in which they claimed Beata was present. Certainly compare and contrast the testimony of our defense witnesses with that of the prosecution, but do not let the prosecutor convince you or anyone that there should be this double standard, that if a witness is inconsistent or cannot recall a date, that as long as it's a defense witness, you should reject that testimony, but if it is a prosecution witness, you should embrace it. I am confident that you will not do that. The next issue, as Mr. Butler himself acknowledged and admits, who spent an inordinate amount of time analyzing the documents, the evidence, the statements, as a military analyst on behalf of the prosecution, he told us quite frankly and quite candidly that Mr. Beata was nowhere to be seen from the 17th through the 31st of July 1995. He told us also that he had no evidence of Mr. Beata from the 1st through approximately the 12th of July 1995. No statements, no records, no documents to support such a theory. Prosecution does not reconcile that with the evidence and the position they're taking in their final brief. They simply do what they're accustomed to doing, ignore it. Ignore the evidence just like you ignore 2D-PW-19. Ignore the evidence just like you would Jakob Benefield. Ignore the evidence just like you would of Zoran Malinic and others. With respect to Mr. Butler and the JEPA issue and the charges brought forth on JEPA, his testimony on 20213 highlights the case that the prosecution claims they have against Beata. The question is as follows. From the 17th of July until the 31st of July, 1995, what did your analysis find as to the whereabouts of Mr. Beata? Answer: I don't believe we have any intercepts or any other information pertaining to his whereabouts during this period. Subsequently, we asked him, when did the JEPA operation start and when did it end? He gives it to us at page 20216, lines 12 through approximately 20. And he offers to us, keep it in proper context, Mr. Ostojic. And I accept it. And then I ask him, give us the timeline of when the operation started and when it ended, so that we'll know if someone who was not there, who did not know anything about it, had any responsibility. He shares with us the civilians were being transported from the JEPA enclave starting the 26th of July, if memory serves. When did it end, sir? I think within 2 days, 3 days, the movement was done. So would that be the 28th or 29th, according to your analysis? Yes, sir. I mean, I believe I have the dates in my report. It was not a very large movement process, 2 days max. I go back to Mr. Butler, and then I ask him at the very next page at 20,217. In fact, am I correct, sir, that there is no evidence whatsoever with respect to Ljubisha Beata involved in the JEPA operation, but for the intercepts that we see purportedly on the 1st and 2nd of August 1995? Answer: to my knowledge, that's correct. I'm not aware of any information. I went on that page to ask him about planning, organizing, assisting, supervising, even facilitating, although I don't accept the definition given by the prosecution. I think it remains unclear what they mean by that. With respect to JEPA, the prosecution, interestingly, in their brief, ignore the evidence of Butler, and they rely on one witness, PW 109. We know and acknowledge Mr. Bada's involvement on the 1st of August 1995, well after the operation ceased to unfold. The prosecution is trying to put Mr. Bada at the Žepa checkpoint well before the August 1st, 1995 intercept. They have no proof, no evidence, no corroboration, or no documents, but for one witness to support that claim. Again, it's not that difficult. If you really believe this, Mr. Prosecutor, there were other people at the checkpoint. You have evidence, video evidence of other people at the checkpoint at certain times. There's no evidence that Mr. Bada was at the checkpoint during or before the operation. None whatsoever. Fair and thorough is what I would have expected. I don't believe we got it in connection with the witnesses. I don't believe we got it with what they call other evidence to support their position as it relates to Mr. Bada, and that is the intercept evidence. And I'd like to turn to the intercept evidence. And as I briefly shared with you, we ended with the witness on the 16th of July. And in the interest of time, and by way of an example, we should look at the 16th of July intercept. I think that it is intercept P1187. And if we could just have that. Thank you. If we could have that placed before the court. Now, this intercept purports to be a conversation at 1100 hours on the 16th of July, 1995, between Beata Tserovic and X. They claim that triage was a code word for murder. They don't accept when Vasic says liquidate or kill, that it means what it says at face value. But they concoct now the word triage as being a code word for murder. Looking at this intercept carefully, as I hope that we would and that you will, who used the word triage during this intercept? Here it is. From recollection, it's used 4 times. All 4 times, it's used by Tserovic, not Beata. The prosecution says, as does their expert, Mr. Butler, that there was no triage of POWs that were conducted on July 16, 1995. Therefore, this must mean, based on their leap of logic, that it must mean to kill. That's not true, and the prosecution knows it. The other intercept or evidence that you should look at is also P12. Now, P1200, thank you, I apologize for that, P1200. This intercept is dated the 16th of July, 1995, at 19:48 hours. It's between two other participants discussing vehicles, issues with wounded and injured people. This surprisingly intercept is relied upon the prosecution to say that others knew, others may have known. This intercept clearly is talking about triage, and the triage of the wounded, and the triage of the sick, and the triage of the people that were left in Bratunac, Potocari, and Srebrenica, excuse me. But you don't have to take my word for it. It's in the document on page 2. If you look at that document on page 2, the word triage appears. And it's ERN 0093596. The 16th of July, 1995, others are discussing triage. Is that enough? I think it's enough to create reasonable doubt. The prosecution simply ignores it. But look at P2567, if you will. It's also dated the 16th of July, 1995. Now, mind you, the prosecution's taken the view that there was no triage, that there was no evidence of wounded. P2567, which is a main staff document dated the 16th of July, 1995, discusses the coordination between various parties in order to transport approximately 100 people from Potocari and Bratunac to Tuzla. You must view the evidence that the prosecution claims as it relates to Mr. Beata, the intercept of the 16th of July, 1995, P1187, together with P1200 and P2567, and respectfully ask yourselves whether their interpretation of the word triage is accurate or correct when used on that date. It is not. And this is just their attempt at an imaginary claim which they so desperately need as it relates to Mr. Beata. Now, we're going to look at a couple other intercepts, and in the interest of time, I may skip some, but it's hopefully covered in our brief in detail. If we look at P1130, which is also an intercept that the prosecution claims identifies Mr. Beata at 1500 hours, it's the intercept between Zorka, Beata, and Lucic. OTP, in their closing remarks, asked a quizzical question and said, this intercept is hotly contested by the Beata defense, and I don't see why. I invite you to look at the 3 copies that you have of P1130. You'll find that in the handwritten copy, nowhere does the word Beata speaking appear. All we see is Beata. Somehow, magically, that appears in the English translation. The typed version speaks for itself, I suppose. Also, the handwritten version, and this witness who testified, clearly, he said during the second half of this document, clearly he said, I want to talk to him. Lucic wanting to talk to Cerovic. This witness, although it was a prosecution witness, clearly stood by that. Now, the prosecution's claim is that Beata wanted to talk to Zorka. I said Cerovic by mistake, Zorka. That Beata wanted to talk to Zoran Malinic. But it was actually Lucic, as recorded by the intercept operator, who wanted to talk to Zorka. It was clear in his testimony, and I invite you to look at that testimony again. Next point that's interesting about this P1130, if you look at the first portion, that seems to indicate that Beata was one of the speakers. Look at the questions that are being asked by purportedly Beata. Is this a man who had knowledge? Is this a man who was well informed? Is this a man who knew what was going on at that time? Or is it logical to conclude that this person had no idea, had no information? His first question, where are they now? According to the prosecution's overall case, Beata should already have known by 1000 hours where they were. He goes on, attributed to Beata, and they've been rounded up, disarmed, everything? How does the prosecution reconcile that? If Beata had knowledge by the 13th, this intercept that they claim is Beata certainly doesn't corroborate that. He goes on to ask other questions that are attributed to Beata. And there is someone to guard them? He goes on, they're locked up, right? Finally, do you have enough room over there? Certainly that individual who was asking those questions did not know, did not have any knowledge, and certainly was not involved in any aspect of either the transportation nor the killing of the Bosnian Muslims. You'll find on the next page where Lucic says, let me talk to him, which is what I referenced earlier, and I invite you to look at this particular intercept operator's testimony in regard to that issue and how steadfast he was and determined that the prosecution's theory is incorrect and that Lucic was actually seeking to speak with Zorka. P1144, temporally connected with the prior exhibit P1130. It's an intercept of the 13th of July, 1995 at 1829 hours. Now this intercept, interestingly enough, the prosecution identifies and says the following in their footnote of all places, 4904, in paragraph 2215 of their brief. With respect to P1144, the prosecution says the following, quote, the intercept clearly shows that there were VRS members who were not informed about the murder operation and who were therefore concerned about screening the captured Muslim men for possible war crimes. Otherwise, they would go scot-free, i.e. be exchanged, end quote. This is at 1829. The Croat intercept that Mr. Beata was captured on, which the prosecution says is exculpatory, identifies a process of selection of potential or purported war criminals and the transfer of individuals to the Batkovsky camp. The prosecution called that intercept, the Croat intercept, deliberately deceptive. They criticized us for not going further and trying to identify where the intercept came from, who recorded it. If you take anything with respect to Mr. Beata, if you look at the 13th, the evidence P1130, the Croat intercept, as well as P1144 and the comments by the prosecution, you'll find that Beata did not have knowledge and was not involved in either the transportation or the killings of the Bosnian Muslims. Quickly, and I apologize for doing it quickly, if we look at P1164, it's the July 14th intercept. The time, 2100 hours approximately. It's an allegation that there was a claim that Beata was instructed to call extension 155. Certainly, as we've tried to display during the cross-examination of this intercept operator and other witnesses, certainly, if this extension was from the main staff, Beata would have known what the extension is and whose extension it was. During the conversation, the individual that the prosecution purports was Mr. Bada clearly has no clue where extension 155 is or who that extension may belong to. And I noted with respect to the 13th of July, I'm sorry I'm jumping, that when you look at the three exhibits, it's P1130, P1144, and the Croat intercept, which is 72D642. Now we come to what the prosecution thinks is their most prized piece of evidence, and that's the evidence on the 15th of July, 1995, and the intercept at approximately 10 o'clock. We do feel that this intercept is suspicious for a number of reasons. One, Krstić denies it. Two, no other intercept, I dare say in the history of this case or any other case, no other intercepts were captured more than once. This intercept conveniently was captured by 3 separate intercept operators. We, at the beginning of this case in August of 2006, told this court in our opening statements that this intercept is exculpatory to us. This does not prove that Bada was involved in any killings. This does not prove that Bada had any responsibility. What does the individual that the prosecution claim says during this intercept? I've waited for 3 days. I've waited for 3 days. He doesn't say, boy, I've been really busy, because according to the prosecution he has been, busy meeting with civilian politicians, engineering groups, trying to gather all this stuff, and we're killing some people here and killing some people over there. He says, I've been waiting for 3 days. Waiting because he just returned. He returned after being away for a couple days in Belgrade. This intercept and the discussion of triage flies in the face of the documents that we have on the 16th of July, 1995. This intercept certainly disputes, rebuts, and contradicts the arguments of the 7th accused and his counsel, where they claim Bada was in command and in control and was able to order. If Bada was able to order or command or control, why doesn't he simply ask Krstić, give me the men. I'm in charge. Simply transfer these men to me. The fact of the matter is that Bada was never in command or control of any such killing operation. This intercept, when viewed reasonably, pragmatically, you'll find that it does not support what the prosecution claims it does, and it certainly doesn't support Mr. Bada's involvement whatsoever in the crimes that have been alleged in the indictment. Quickly to turn to a third piece of evidence that the prosecution seems to rely upon. And their third piece of evidence can uniquely be described in less than 7 pages. They claim that the Zvornik duty officer logbook supports some of their preposterous propositions. The Zvornik logbook was tainted, as we know, because of PW 168. He not only changed the dates as described by Mr. Gogic, also as identified by their expert Kathleen Barr, they were uncertain who wrote the entries as it may relate to Mr. Bada. Conspicuously, all the entries as it relates to Mr. Bada either appear at the very last line of the document or are inserted at the beginning of the document. Reliance on documents such as these, when we know there was not a chain of custody that we can respect but was actually tainted by an individual who needed the document, who held the document for well over a year in his possession, who admitted that he made alterations and dates within the document, is clearly suspicious and should not be given any weight. The prosecution, when they boldly told you they had, I guess, 4 or 14 or whatever number of witnesses that saw Beata, the intercepts that they claimed conveniently had no discussion of triage with people in Bratunac or Potocari, when in fact it does. The reliance on the documents such as the Zvornik Brigade should be rejected. But what they tell you is, subtly, we do not have evidence as it relates to Mr. Beata in any interim combat report, in any regular combat report, from either a battalion, a brigade, a corps, or main staff document. We have no correspondence sent by Beata to any individual. We know we don't have any correspondence sent to Beata from any individual. We don't have any correspondence that mentions, refers, or identifies Mr. Beata. We can't give you the Bratunac Brigade Duty Officer logbook. There's no evidence against Mr. Beata in that regard. The Drina Corps Duty Officer logbook and other documents from the Drina Corps do not show or support Beata's involvement at all. Tactical intercepts taken from the battalion and the brigade and the corps do not support Beata's involvement at all. The SDS office records of appointments or an appointment book, they haven't produced that. No evidence of Beata that he was present there at any time, under any circumstance. Any personal notes from PW 161, Deronic, Nikolic, PW 162, none. How about any records from the MUP of either Bratunac or Zvornik? We know Vasic liked to write letters, proudly explaining his involvement, although getting carried away, according to the prosecutor. He really didn't mean killing. He really didn't mean that he's in charge of the entire operation process. He was intimately involved with Mr. Deronic and the POWs, as reflected by his very own documents. Do the MUP documents support that Mr. Beata knew or was involved in any way? Of course not. All they're relying on are 3 intercepts, a logbook of less than 7 pages, and 4 individuals from Bratunac for their case against Mr. Beata. Not only was their case not fair, not only was their case not thorough, and I don't blame him for that, there is no other evidence that they could have brought forth. Had they been able to, they would have. They knew exactly what they were doing. They knew exactly how to bring a case against Mr. Beata, and they did a remarkable job weaving some of these loose ends to try to shift and point the finger at Mr. Beata. I respectfully ask this court not to accept such false testimony and loose claims by witnesses who I believe you'll find to be less than credible and worthy of giving no weight. I ask this court respectfully to dissect the information and the testimony of these individuals, not as a prosecutor would, to try to confirm a theory of one size fits all VRS members of guilty of some complicity or some involvement in the Srebrenica murders, but to view it openly and honestly, as I expect and am confident that you will, to view the evidence in light of the defense, and to look at what the reasonable interpretation should be. Accept Mr. McCloskey's challenge that if there are 2 reasonable interpretations, the defense should prevail. And I find that if you do that you'll find the evidence and the case against Mr. Beata to be not only thin, but to be non-existent. I want to touch upon, in my last moments that I have with the court, not only our appreciation for everything that you've done and allowing us to bring forth our case and evidence. We fell short. I tried to call Milos Tomovic. I tried to call other witnesses. We were constrained with time. We couldn't do it. That evidence existed for Mr. McCloskey to call him. I'm not shifting the blame on him alone. I feel bad for Mr. Beata. I should have and tried on 6 different occasions to impress upon certain individuals the importance of coming before this court. Many were hesitant. All did not come forth as we had expected, but I am confident that because it's not our burden of proof, that the court will not hold that against us, but that the prosecution was required to bring forth that evidence, and they failed to do so. Finally, in our brief, I addressed sentencing. We are contentious with the prosecution for many reasons. In their final brief, they say Beata was arrested. We say he voluntarily surrendered. You saw the evidence as it relates to Mr. Beata with the Minister of Justice in a conference room saying goodbye to his family, being flown in a private airplane to the Netherlands in The Hague. He was not arrested. They brought forth no evidence of his arrest. We saw the video, and we know that he turned himself in voluntarily. With respect to the sentence imposed, the prosecution said in his opening remarks, and he identified Mr. Schindler, and I'm sure we've all seen the movie. There's little doubt that more could have been done. There is little doubt that more should have been done. I'm convinced as to who is responsible and why they would be responsible, and convinced that Beata is not. However, if you accept and adopt the standard that the prosecution is offering to you, and that would be, as I coined it, the Schindler standard, then yes, Mr. Beata, with all due respect, sir, perhaps should have done more, perhaps could have done more. In light of that, and in light of Mr. McCloskey's comment and idiom that Beata cannot hold a candle to Blagojevich or any commanders, I suggest a sentence, if you find any of the evidence to be credible against Mr. Beata, and I underscore that, if you find that he was present and was able to do that, a sentence of no more than 9 years. Thank you very much, Your Honors.
Thank you, Mr. Ostojic. All right. We were discussing if we have any questions for you, but we've decided that we have none at this time, at least. Ms. Nikolic or Mr. Burgon, I don't know who will be. You have two options. Either start now and we'll break in 70 minutes time, or break now and start with your closing arguments after the break, whichever you prefer.
Dobar dan, časni sud.
Good morning, Your Honor. We prefer the second option, frankly, so that we can organize ourselves and prepare and start after the break.
We'll have a 25-minute break.
All rise.